The first phase of Meng Wanzhou's extradition hearing comes to a close. This week's arguments are focused on the issue of double criminality and whether Meng's alleged actions would also be a crime in Canada. The US has charged Huawei's chief financial officer with fraud over allegations that she misled HSBC Bank about Huawei's relationship with an Iran-based subsidiary, putting the bank at risk of violating American sanctions against Iran. Canadian government lawyers say the issue is fraud, which is a crime in both countries. They told the court that had the incident taken place in Canada, it would be an actionable case of fraud and that HSBC faced considerable reputational risk. But defence lawyers argued the allegations are not criminal, as Canada does not have the same Iran sanctions. And if the sanction risk is taken out, the criteria for fraud fails. They say the case therefore doesn't meet the test of double criminality, a point extradition lawyer Gary Botting agrees with.
The sanctions against Iran are a non-starter with respect to whether or not there's a determination of criminality in Canada. It doesn't apply to Canada. It's a United States law that they're trying to enforce here in Canada.
At the end of this phase of the hearing, the judge, Justice Heather Holmes, said she would reserve her judgment. But if she decides that the test of double criminality has been met, then this hearing will continue with further court dates already penciled in April, June and September. Dan Williams, CGTN, Vancouver.